Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkar. In this video, I am going to touch upon the anticipatory bail in Ndps Act cases. అందరికీ శుభోదయం. Generally, anticipatory bail will not be given as a rule in Ndps Act 1989 cases. Because the act is a stringent act, action should be taken against the peddlers of narcotic drugs as well as those who are consuming lot of cinema actors, the psychotropic substances. To curb the same, to prohibit the same, to prevent the flow of NDPS, narcotic drugs and psychotropic substances, the act has come in the year 1989. Previously, it was there with only Excise Act. So, anticipatory bail normally can never be granted in NDPS cases except in extraneous circumstances cases. Supreme Court judgment. Justice Pankaj Mittal and Justice K.V. Vishwanathan, two judges bench. In the case of Dinesh Chander versus State of Haryana, SLP criminal number 9540/2025, on 7th July, just day before yesterday, held that bail is not granted even by the Supreme Court in NDPS Act cases. And Punjab and Haryana High Court, they refused bail. They committed no error. Why should you come to us on appeal? Waste and clearly cheppindi. Punjab and Haryana High Court has already denied bail, denied anticipatory bail in this NDPS Act case 1985. Right. Now, coming to the facts of the case, ఇది కూడా కొంచెం మనం చూసుకోవాలి. అంత తెలివితేటగా వచ్చి ఉంటారా? సుప్రీంకోర్టు రావాలంటే లక్షలు ఖర్చు పెట్టాలి. రైట్. Dinesh Chander's name or the plaintiff or the appellant's name came to the notice of the police during a confession statement given by the co-accused. Confession statement, or you can call it as a disclosure statement of the co-accused. Actually, 60 kgs of DODA post and 1.8 grams of opium was seized from the possession of the co-accused, and during the course of inquiry or investigation, they have disclosed that they were supplied, or the so-called Dinesh Chander supplied the same to them. Therefore, naturally, Punjab police, they added him as a co-accused. Since he has become a co-accused, he approached the Honorable High Court of Punjab and Haryana to grant him anticipatory bail, which was refused. Then he came to the Supreme Court. Of course, the defense lawyer, he says that his name was not there in the original FIR. His name came into light only after the disclosure statement of the co-accused. You all know confession given before the police is irrelevant. Confession given before the mediators in the presence of police is irrelevant. Even though confession is there, it is only a weak piece of evidence. So, a case is, in order to fabricate a case against me, the police concocted the so-called confession statement. No contraband was recovered from him. Right. And the state says, please remember, they opposed the anticipatory bail plea, stating that commercial quantity of contraband was seized from them. Section 37 of the NDPS Act, please remember. Commercial quantity, no bail. And actually, the custodial interrogation is also necessary from this person as to where he got it. So far, they have established that this man, Dinesh Chander, supplied them the so-called opium, that thing. From where did he get it? This has to be done only through interrogation by the police. As usual, he said police have falsely implicated him. His name is not there. But the state produced the telephonic records, bank accounts or bank transactions. Oh. The court established that the conversation as well as bank transactions reveal that there is a connection between the accused and these persons, accuser and co-accuser. So, no case of anticipated bail. Right? Just now, Supreme Court said Punjab and Haryana Court has not done anything wrong. They have refused correctly. But we will discuss two case laws. One in support of anticipatory bail and another negative. September 2024, where the Honorable Supreme Court of India granted bail, Justice B.R. Gawai and Arvind Kumar and K.V. Vishwanathan. Negative example. They asked the West Bengal state to file an application for the cancellation of bail granted by the High Court of Calcutta to the accused person. Cancellation of anticipatory bail granted by High Court, because Supreme Court said it is not possible to give anticipatory bail to the accused person. So the grant of anticipatory bail is a very serious issue. This is a case law, that is Anrul Sheikh versus State of West Bengal 2024. Negative example. Or support of no grant of anticipatory bail 2024 case. Then Supreme Court has given bail, anticipatory bail in another case this year, April 2025. In the case of Kulwant Singh versus State of Punjab 2025, April 2025, Honorable Supreme Court of India was pleased to grant anticipatory bail to the accused Kulwant Singh. The case is that he was in possession of tapentadol, Tapentadol, tapentadol hydrochloric tablets. Of course, these tablets are used to treat the moderate to severe acute pain. These are medically agreed. Of course, this tapentadol is not mentioned in the schedule of the so-called narcotic drugs and psychotropic substances. So, therefore, it is not a psychotropic substance. Therefore, he was given anticipatory bail. Likewise, you might have seen present days, suppose you go to any medical shop, if you ask for Ultracet, ULTRACT, they don't give because it is a psychotropic substance. Like baga, kaala neppulu unte, Ultracet, doctor prescription tappa, adi evaru. దాని గురించి సరే మనకి ఇండియాలో మనకు తెలిసింది అనుకోండి, అల్ట్రాసెట్ బదులు దాన్ని అల్ట్రా కింగ్ అని వేరే పేరుతో అమ్ముతాడు. ఇది కానీ ఈ అమెరికాలో వస్తుందే లేదు, ఒప్పుకోరు. అన్లెస్ ప్రిస్క్రిప్షన్ ఈజ్ దేర్, యు ఆర్ నాట్ గివెన్ ఎనీ మెడిసిన్. జనరల్ మెడిసిన్ సి విటమిన్ ట్యాబ్లెట్స్ అవి ఇస్తారు. అయితే మేము మోకాళ్ళ నొప్పులకి గ్లూకోజమైన్ అని, ఎంఎస్ఎం విత్ గ్లూకోజమైన్ అని క్రిక్లాన్ అని రాసి ఉంటుంది. రోజు 2 వేసుకుంటారు. అవి తప్పితే ప్రిస్క్రిప్షన్ ఉంది చచ్చినా ఇవ్వరు. అక్కడైతే అఫ్కోర్స్ అక్కడ కూడా ఇవ్వరు. బట్ ఎనీథింగ్ ఈజ్ పాసిబుల్. మన దేశం మనకు దాన్ని తక్కువ చేసి మాట్లాడుకోవడం మంచిది కాదు. సో ప్లీజ్ రెఫర్ టు దీస్ 2 case laws which are very very important. So generally you have to observe that anticipatory bail should not be given in NDPS Act cases because of the legislation. అందుకని ఇంటర్ప్రిటేషన్లో చెప్పాను, you have to understand the legislative intent, why the act is made. That's very very important. So please read the case laws and enrich your legal knowledge. Thank you.